Christopher Garcia. Welcome to the 5th Annual World Intellectual Property Day celebration, sponsored by the New Mexico Small Business Development Center, called the Technology Commercialization Accelerator, TCA. We are here at the New Mexico Institute of Mining and Technology in Socorro, New Mexico. The TCA office has been celebrating World IP Day to bring intellectual property awareness to the New Mexico small businesses, entrepreneurs, innovators, and residents of New Mexico. Each year, we celebrate Intellectual Property Day on April 26th. This year, the 26th lands on Saturday, and I thought today would be the best day to present and share intellectual property information to all of you. So thank you for attending. As you may know, intellectual property includes patents, trademarks, copyrights, and trade secrets. There exists a global organization called the World Intellectual Property Organization, WIPO, that organized this celebration in 1970. This year, WIPO has picked music as the theme for World Intellectual Property Day. The theme is IP and music. Feel the IP beat. Right? You all feel the IP beat? Creators and innovators worldwide use intellectual property to translate their ideas into assets. These properties create economic and social benefits that improve the lives of everybody. My name is Estefanita Rawlings, and I am the TCA Center Director and the coordinator of this event, and I welcome you to the World Intellectual Property Celebration 2025. Right now, I'm going to read from the WIPO website regarding the celebration. Music permeates every sector, and IP fosters the presence of music beyond its own realm. From film, entertainment, and technology to fashion, video games, and consumer goods, intellectual property rights empower cross-industry connections with music, enabling creative synergies and innovation across the sectors that fuel economic growth. Even when it's not in our minds, the beat and rhythm of music and intellectual property are always present in our lives. World Intellectual Property Day 2025 highlights how creativity and innovation, backed by intellectual property rights, keep a thriving music scene that benefits everyone, everywhere. This World's IP Day invites us to explore how intellectual property rights and innovation policies empower creators, innovators, and entrepreneurs to bring fresh ideas to the music industry, safeguarding the work of songwriters, composers, performers, and all those who shape the music that move us. On World IP Day, we celebrate the contributions of creators, innovators, and entrepreneurs who are pushing the boundaries of innovation and creativity to make music that brings people together, invokes powerful emotion, drives change, and inspires a more innovative future. Let's come together to honor the universal language of music and the talented creators, innovators, and entrepreneurs who continue to develop new sounds, styles, technologies that shape the future of music and help us feel the beat of IP. So today we have two different presentations. Our first will be presented by our Southwest Regional United States Patent and Trademark Outreach Office in Texas. Reynaldo Vasquez and Jacob Choi will present on intellectual property basics and USPTO resources. The second presentation will be provided by Luis Ortiz, who is a registered patent attorney for Ortiz & Lopez, PLLC in Santa Fe, New Mexico. Mr. Ortiz will be presenting Survey of Copyright Law and Practical Considerations for the Artisan/Musician. Before we hear from our speakers, I would like to let you know about my TCA Center here in Socorro, New Mexico. New Mexico SBDC centers fall under the Small Business Administration umbrella, where the SBA is at the federal level, the SBDCs are at the state level. We have 19 centers here in New Mexico at the different higher education institutions that help clients with business startups and sustainability. We have two special programs, One is the International Business Accelerator, located at Santa Teresa, New Mexico. This center provides assistance to businesses needing export assistance. The other program is called the Apex Accelerator. They provide assistance to businesses working on getting compliant to contract with the government, tribes, and county agencies. The mission of the SBDC is to develop skilled entrepreneurs and strong businesses. Here at the TCA, we like to move our clients forward with their ideas as they work towards commercialization. We provide education and training events to help our innovators learn the process of protecting their intellectual property. Our other role is to provide cybersecurity awareness to the small businesses of New Mexico. So thank you, New Mexicans, for coming to this event. Feel free to contact me if you have any questions regarding your idea and moving it forward. We have our meetings via Zoom or in person, whichever is convenient to the client. Now, I would like to move forward with our program and a little bit of housekeeping, okay? I would like to thank Christopher Garcia from the Valencia County SBDC in Los Lunas, New Mexico, for monitoring the webinar. He will have us all muted until Q&A time. So if you have questions, feel free to put it in the Q&A. It may be answered by some of the hosts or will be answered during the allocated Q&A time. Please note that we are unable to provide legal advice. We will be recording this event, and the recording will be posted on our YouTube channel, New Mexico SBDC. Also, you will be receiving a copy of the presentations. In return for the presentation, recordings, and handouts, we would appreciate your participating in our survey that will be done during the webinar after our second presentation by Mr. Ortiz. This survey helps us become a better IP, intellectual property service provider, and it helps us with our funding. Now I'm going to turn the program over to our USPTO presenters, Reynaldo Vasquez and Jacob Choi.
Hello, everybody. My name is Reynaldo Vasquez. You call me Ray. I'm the Regional Outreach Officer here at the USPTO Southwest Regional Outreach Office in Dallas, Texas. And we do cover the state of New Mexico, so I'm happy to be here with you guys today. Jacob's going to start off the presentation, but I just kind of want to do a quick introduction of myself. I came from the SBA world, so I used to do economic development for about 11 and a half years. Used to do international trade, veteran business development, got into research and innovation funding, and then I transferred over to the USPTO about 4 years ago. I'm glad to be here helping educate the public on intellectual property, helping with stakeholder meetings, and when there's no hiring freeze, recruitment efforts. Today, we're going to be talking about intellectual property basics. So we'll be talking about those fundamentals and some of the USPTO resources that are available to the public. So I'll pass it over to Jacob.
All right, well, thank you, Ray, and thank you, Stephanie. Good afternoon, everyone. I'm happy to be joined with Christopher, Ray, and Louis. I think they will be part of the discussion later on. So also, I'm excited to celebrate the 5th Annual World Intellectual Property Celebration with the members of the SBDC and stakeholders. My name is Jacob Choi, Regional Assistant Director at the USPTO Southwest Regional Office. And I've been with the USPTO for the past 24 years now, served as a patent examiner way back when, and also served as a supervisory patent examiner for a number of years. In recent years, through the passing of the American Banks Act of 2011, I had a pleasure of opening the Rocky Mountain Regional Office, being there for about a couple of years to kickstart that office, and moved to Texas, Dallas, Texas, to open up this very office, Southwest Regional Outreach Office, and it's been about 9 years for me. Today, we'll be introducing the basics of intellectual property, including topics like patents, trademark, copyrights, and trade secrets, and resources for the next hour or so, and with the Q&A. So with that, if I can have Ray start presenting the slides so we can kind of go through. So this is our first slide, and one thing that I will want to kind of point out with the slide is the R in a circle next to the USPTO logo. We are the only federal government agency that actually holds a registered trademark. So it took us a couple 100 years, or 200 years or so, but we are there. So We'll talk more about the trademark, but just wanted to kind of point that interesting fact. Next slide. So as I mentioned before, we're going to talk about intellectual property basics today. So again, just to emphasize throughout the presentation, if you guys have any questions, please feel free to use the Q&A box to submit them. We will have a portion of the presentation at the end where we can actually address some of your questions live. So intellectual property rights are actually found in U.S. Constitution. It reads the following in Article 1, Section A and Clause A. And it says, the Congress shall have power to promote the progress of science and useful arts. I want to pause here for a second and say that science related to technology and innovation space and useful arts is probably referring to the copyright protection, which is actually a focus of the 5th Annual World Intellectual Property Celebration. By securing for limited times, okay, we'll talk more about that, to authors and inventors. See, authors, again, is referencing copyright protections, as well as inventors are talking about innovators who would invent something that is new and useful arts, okay? The exclusive right to their respective writings and discoveries. Again, this section of the Constitution is essentially focused on the copyright protection and patent protection. So just wanted to point that out as the Constitution. It's been 200+ years, and this is our founding father who knew the importance of protecting intellectual property. So next slide. To give you a quick overview of the U.S. Patent and Trademark Office as of fiscal year 2024, we employ over 14,000 employees. As you can see on the left blue block, we have well over 9,000 patent examiners who actually examines your non-provisional patent applications. And we also have trademark examining attorneys, well over 700 of them, that actually take care of the trademark registration. Also, both patent and trademark side, we do have administrative patent judges as well as trademark judges, as noted in this slide. And coming into the middle of the slide, you'll see that within fiscal year 2024, we received well over 600,000 patent applications. And that same time period, we also issued well over 300 patents during that time period. A lot of people think that by filing a patent application and getting a patent from the USPTO, it is in fact a very tough and long journey. However, they need to be really aware of that. The likelihood of getting a patent is not small. It's actually somewhere in the middle between 40 to 60%. Depends on your innovation and your idea and how you would represent your non-provisional patent application. Well, again, we'll talk more about that later. On the trademark side, we have received well over 700 trademark applications and have registered well over 300 applications. In the middle there, at the bottom, what you're seeing is our beautiful campus at the headquarters located in Alexandria, Virginia. Next slide. Here, we are looking at the US map, obviously, and I wanted to point out that our headquarters is located in Alexandria, Virginia, but thanks to America Invents Act of 2011, was passed by Congress, it actually allowed the US Patent and Trademark Office to open up 4 regional offices across the country in different time zones, starting with the Detroit office there that you're seeing in the green area, followed by the Rocky Mountain located in Denver, Colorado, and the Silicon Valley office in that orange area, but the best one, Dallas, Texas, covered in those states' blue area. So in that order, we opened up regional offices to really, there are 3 different focus areas of the regional office. It's number 1, to hire local talents. Since the opening of my office, we have hired many of the patent examiners and PTAP judges locally in this area. And historically, people have not been willing to move to the DC metro area, but we are moving out across the country to really have them hired locally. So that was one of the objectives. And second objective is to have open door policy to our stakeholders that is utilizing and needed information about intellectual property by having a physical space People can come in and ask questions about intellectual property, and we have been doing that in many different shapes and forms for the past 9 years. Another thing that we're big on is going out to the communities and areas that we don't typically go to, as you can see in that blue area, and to really conduct information sessions like very much like this one, and go out and all shapes and forms of intellectual property stakeholders to talk about intellectual property. How does a patent examination work? And what are the important key factors that the stakeholders should know? And also the troubleshoot some of the pending cases that's been filed before USPTO, be able to address issues and concerns that stakeholders might have. The last thing that I will mention with this particular slide is that we are hoping to open up another office in Atlanta, Georgia, hopefully by end of this year. And as I mentioned, American Invents Act was passed in 2011. And in last December, there's another bill that was passed by Congress called the Unleashing America Innovators Act, UAIA. And that's going to actually allow us to open up this fifth regional office in Atlanta, Georgia. Next slide. Here, coming to the Southwest Regional Outreach Office, we are located again in Dallas, Texas. Then the image that you're seeing is our federal building there. It's called the Terminal Annex Federal Building in front of the Reunion Tower. So if you have not been to the Dallas-Fort Worth area, and if you are in the area, we are open to the public, as you can see there, from 9 to 5, Monday through Friday. So please come and visit us. We have the facilities where you can use, such as you can conduct some patent and trademark search. You can even conduct interviews with our patent examiners in the room. Also, we have a hearing room and other public spaces that you guys can utilize, and as well as for you guys come in and ask any questions that we might be able to address with respect to intellectual property. We do house a number of patent examiners and PTAB judges, and we do have managements and staff members that are working out of this office. Just a side note, we occupy part of the Terminal Annex Federal Building, first floor, and the entire 5th floor. But we do have other agencies that are actually coming and working out of this Terminal Annex Federal Building. Next slide. Okay. Let's talk a little bit about intellectual property. As Stephanie mentioned earlier, it is very important that to start with the fact that intellectual property is what we consider to be an intangible asset. However, we are very familiar with the tangible assets, such as your car, things that you own, like your house, and a lot more, right? So intellectual property is some sort of an idea or innovation that you come up with in form of an idea. Then you protect it through the intellectual property system, such as coming to the USPTO and filing for patent application. Maybe it's a trademark registration. And I know Louis is going to talk more about the copyright protection. And there's also another form, it's called a trademark, trade secret, I'm sorry. So with that, you are essentially protecting those assets very much similar to properties that you can touch, and you can actually keep it to yourself. You can sell it, you can license it, and more. Next slide. Here's my old phone. I think this was a Samsung Galaxy Note 5. So when you look at widgets and devices like this, you can identify many of the intellectual properties that are associated with it. Let's start with the design patents. So design patents, there are 3 different types of patents, which I'm going to cover next. But it's a different types of patent that you could get to protect the look and feel of this widget. For example, this curved design, curved bezel that Samsung phone typically has, the older models, they can actually protect that through the design patent, okay? Copyright protection also includes things like software code, instructional manual, and a ringtone. And coming to the right, trademark is actually the one that stands out in terms of the brand recognition, goods and services that are associated in commerce. In this case, the word Samsung is protected under trademarks. Also, the product line, Galaxy Note, is also protected under trademark. So when it comes to a lot of the common patents that we deal with at the U.S. Patent and Trademark Office, it's actually the utility patents. So that actually includes things like the camera, battery, screen, antenna-related technology, data processing methods, and more. And then last thing that I would mention here in this slide is a trade secret. I put a question mark there because we don't know what it is, but it certainly provides a Samsung and other iPhone manufacturers to giving them that edge or that sort of secret ingredients to make sure that that device compared to other devices that may exist in the marketplace, they had this market advantage. Next slide. Okay, let's talk about US patents. So what is US utility patent? On the right, you are seeing a Thomas Edison's patent on the light bulb idea. It literally lit up the world. So the US government grants a patent to give the patent owner. This is a patent owner. We don't usually say inventors because sometimes inventors or inventor may be working for a company, right? So this is here. The patent is granted to a patent owner, which can be a company or it could be yourself, the right to exclude others. Okay, so sort of is a negative right, excluding others from making, using, selling, or offering for sale the claim invention. So today we're not going to talk about claims, what is claim and in the patent application, but what is essentially is that in your non-provisional patent application, the last section of that application, this section is called claims. So using words, essentially you are defining the metes and bounds of your intellectual property right. So this is a very important key ingredient that makes up your non-provisional application. And also, this is only good in US. This patent protection that we're talking about is territorial. So the patent protection that you may get from US Patent and Trademark Office is good in United States, okay? Another thing that I would mention is that it's for the limited time, and very important aspect about patent is that it's an idea that you exchange to the, it's a public disclosure for, and you get that exclusive right, but in return, you have to tell us, you have to tell the public as to what you have invented. And you may be wondering, why do I want to do that? This is how the ecosystem works, where people can look at your idea and then even asking themselves as to, I can do better. So looking at this image that you are seeing, the old conventional light bulb idea, people have looked at that and studied that idea, innovation, and then further made further improvements thereof. So you can probably imagine right now and think that there's a lot of different type of light bulbs that exist right now. For example, light emitting diodes, right? So that's how the system works. And I mentioned about this being the territorial, and it protects a new and useful process, machine, and manufacture, composition of matter, improvement thereof. I do want to talk about this a little bit. A lot of people think that my idea, in order to get a patent or obtaining a patent, it has to be a brand new idea. But a lot of times, many of the times, the application that I reviewed as a formal patent examiner is that it was a lot of things that related to improvements over existing innovation. So think about that a little bit. Next slide. So as I mentioned before, there are 3 different types of patents. We're going to quickly go over that right now. So most common one, we start with the utility patent. And the image that you are seeing is from inventor Abraham Lincoln. He is the only president that actually holds a patent. And this is a sort of a vessel that actually has a system, a bladder system, where I call it. When your vessel gets stuck in the shallow water, Abraham Lincoln thought that by blowing up the bladder system, the boat will get unstuck. So interestingly, he did not have a prototype for this innovation, but that doesn't stop him for filing for patent application, okay? So protects the following categories of innovation for up to 20 years. So when we talk about 20 years, that's the term exclusive limited time that you will get if you do get a patent from the US Patent and Trademark Office, and it's based on the filing date of your non-provisional application. Okay, we'll talk a little bit about provisional and non-provisional application, but 20 years starts, the date starts on the non-provisional application filing date, okay? And then, as I mentioned before, it protects things like process, machine, article of manufacture, and composition of matter. Next slide. So as I mentioned before in that sort of a Samsung phone that I described, sometimes the look and feel of a widget, or in this case, design patent can be protected. In this example, what we are showing you, you may be thinking it's a Coke bottle, but it's not. Take a look at the inventor's name, C.J. Root. So it's actually a root beer bottle that is being protected here, look and feel of that. And that protection is good for 15 years, the time that you get a grant from the USPTO. So slightly different, 5 years less. Also, it's the clock starts at the grant date, not the filing date of your non-provision application. Another interesting thing that I want to note here is that next to the patent number on the right corner, you will see a letter D designation if it's in fact design patent. For the utility patent, you will not see any letter Ds or Ps, okay? Straight out numbers. But for the design patents, you'll notice that there's a letter D that are associated with it. Next slide. So the plant patent is something that is not common. However, if you can definitely protect a sexually reproduced, distinct, and new plant varieties up to 20 years of filing date of your non-provision application. Interestingly, this one, you do not need to pay for the maintenance fee like the utility, where you pay the maintenance fee at a 3-year mark. I think it's a 3.5, 7.5, and 11-year mark. But for the plant patents, you do not need to pay for the maintenance fee. On the right, the image that you're seeing that all of us are very familiar seeing during holiday time period. Again, on the top right corner, you're seeing the letter P or plant patent. This is a very old one. The newer one would say letter P and a number association. So again, utility patent, just a straight out number. Design patent, you'll see a letter D designation. For the plant patents, you'll see a letter P. Next slide. Okay, here is a path to a patent, especially for the utility and plant patents. Design patents you do not have option to file for provisional application. So let's focus on the utility and plant patents here. So you have a new idea. In order to get the intellectual property right protection through the patent system, this is the roadmap, okay? It's optional to file for provisional application. And provisional application, in my opinion, it plays a critical role, especially the passing of the American Invents Act. Previously, we were under the old system, first to invent. Now it's actually first to file. So the filing date of your either provisional or non-provisional application plays a very critical role, okay? So provisional application is good because you can, with a smaller requirement, a minimal requirement, you can get that effective filing date. It gives you time to get ready to file for non-provisional application. Maybe you can talk to other investors and other inventors for that partnership. It gives you that grace time period. And then when you're ready to file for non-provisional application, you can do that. And provisional application, by the way, it does not get examined by our patent examiners, okay? So non-provisional application is the one that actually gets examined. It has more requirements and it has additional fees. And then once you get a patent from us, hopefully that's going to happen. That protection, again, for the utility patent is good for 20 years, the time that you file for the non-provisional application date and onwards. Okay. Next slide. So for the next 3 examples, I kind of like this section. Hopefully you guys will enjoy. So what we are going to do is play a little bit of role as a patent examiner. As I mentioned before, as a patent examiner, you review your application, and then the most critical, important part of the non-provisional application is to be able to look at the claim of what is the applicant really claiming, and then be able to look at that claim, determine the meets and bounds, go around, do a prior art search, do lots of research as to what is currently existed at that time the invention was discovered, and be able to bring it back to the desk and then be able to explain under the statutes and US codes as to, is it patentable? Is it a new idea? Is it a non-obvious idea? And be able to write that in a form of a write-up is what we call office action. So we're going to play a little role game here, and section called the Weird and Wonderful Patents, Innovation Knows No Boundaries. So what I would like to do is I will show you a quick description, a brief description of this idea, give you a moment to think about, have a visual as to what is this thing actually going to look like. And then I will turn over and show you the image, okay? So next slide. So this one is titled as a TV control device. The patent explains this TV control device can adjust volume and more from comfort of your sofa. Variable adjustable length and considerably less expensive and functions efficiently. Now, I can't say that the claim is written this way. Again, just an example here, a brief description of the idea. So have an idea as to what this thing might be. I'll give you a few more seconds here, and then we're going to turn the page. Ray, go ahead and turn the page. So ask yourself, were you thinking about this idea? I don't know. But this was invented back in 1976. I remember growing up, my dad would always tell me, hey, son, can you get up and change the channel or increase the volume? This is an old set television. Back then, we did not have a remote control. So this person came up with this idea that I want to be sitting in the comfort of the sofa. I do not want to get up, but at the same time, using a sort of a extendable alligator type of a device or widget and be able to change the channel and increase the volume and maybe even turn on and off the television. So you have to really appreciate the fact that patents or patenting the idea is all about problem solving. Okay, this may be a small problem, but look, this was invented back in 1976. So turn back 30, 40 years after that. And we are essentially doing the same problem solving by there has been an innovation throughout that time period where there's better housing, maybe battery technology, circuit board, infrared light source being a very important aspect, right? Maybe even a Bluetooth technology. Through those innovations, we have now what's called a remote control, right? But yet, looking back to this particular patent and problem solving, essentially the problem solving is essentially the same thing, right? But at the same time, other things have evolved. So thus, that problem solving looks quite different now compared to back in 1976. So again, I want to emphasize is the word patenting the idea typically does not have to be a brand new idea, but it's an improvement thereof. Okay, we'll do two more examples, okay? So bear with me. Next one. This one is titled Fresh Air Breathing Device and Method. This patent explains that this fresh air breathing device and method makes it possible to breathe in smoke-filled room while waiting to be rescued from a hotel fire. It enables the user to breathe fresh air through a tube. Give you guys a brief moment to think about, have a visual aid as to what this thing may look like. And let's go ahead and flip to the next slide. And here's another invention. Now, like I mentioned, the title of this section of the presentation is Weird and Wonderful, right? So back in 1982, Mr. William actually had invented this breathing device in case of an emergency. Maybe the building was caught on fire and you do want to survive, get a fresh air. Now, not the best idea. The definition of the fresh air can be a little bit slightly different here, but actually this innovation actually was used in a movie film. So you can take it as what it is, but sometimes innovation is kind of weird and wonderful. And sometimes it saves lives. All right, next slide. This is the last one. This one's titled Pet Umbrella and Leash. I think everybody gets this one. So this patent explains, here's a new must-have pet gadget that combines pet umbrella and leash. This gadget will protect your pet from inclement weather conditions while also serving as a leash for the pet. Like I said, everyone typically gets this. So think about what this idea may look like. And then we'll flip the page. And here it is. This was actually invented 2005. Essentially, it's like a reverse mechanism of how the umbrella should look like, but it's really to protect those our favorite pets. So again, I think you can actually purchase this item in Amazon still today. So anyways, ideas And patenting your idea sometimes can be fun and also weird at the same time. So just wanted to say that. With that, I'm gonna actually turn it over to Ray. Ray's gonna cover things like trademark, copyright, and trade secrets, as well as some of the resources that we have at the USPTO. Thank you.
Thank you, Jacob. And just a reminder, if you guys want to ask any questions while Jacob and Mr. Ortiz are on the sideline, you can feel free to ask. They do have a lot of patent background, so specifically, that's something that they can help you with. But as you know, intellectual property, once you're involved with it, you tend to learn how other forms of intellectual property work. And that's basically what we're trying to do today, is really have you understand what patents work, trademarks, copyrights, and trade secrets. These are what we call the fundamentals or basics of intellectual property. So let's talk about trademarks. Trademarks can be actually very powerful. They don't seem to be, but if you know how they work and operate, they can definitely become powerful. And every individual that goes into commerce potentially has trademarks. They can be called common law trademarks, but they are definitely trademarks. That definitely helps with jurisdiction, especially if you register it with the USPTO. That gives you federal jurisdiction, which is the US itself. So a trademark, a basic definition, is a word, phrase, symbol, or design, or a combination of words, phrases, symbols, or designs that identifies and distinguishes the source of goods as of one party from those of others. So in short, there's a source identifier. You also want to look at trademarks into consumer protection rights. It helps individuals identify products, goods, and services that an individual may have. A service mark is interchangeable to a trademark. It's the same as a trademark, except it identifies and distinguishes the source of a service rather than a product. So a lot of times people that are doing like a plumbing business won't necessarily say it's a service mark. They'll just say it's a trademark because it's interchangeable. But that's basically what a service mark would be. I'm sure you guys see trademarks every day, here, especially in the US. They can be words and designs. These are some of the most famous and recognizable trademarks that you'll see out there. Starbucks, Nike, Target. As soon as you hear the word, you think of the logo automatically. And, seeing the word or the logo or the design, it gives you an automatic picture of what the product and services that you're about to purchase. So it definitely helps consumers identify what they're going into. So keep that into consideration, because infringement of trademarks is usually a number one issue, which is what we call likelihood of confusion for trying to receive trademarks. So if you have a trademark that you want to register, you always want to do your due diligence and do research. Same thing with patents. You definitely want to do research behind it, copyrights the same way. That you're making sure you're not infringing on somebody else's intellectual property. That is something that we can help you train with ongoing training that we have, but just keep that into consideration because it is your due diligence to do as an entrepreneur, small business owner, to protect your intellectual property and make sure you're not infringing upon others that have protection. So trademarks also have non-traditional marks. So colors is one of them. I'm sure you recognize these products already. The Tiffany blue is a trademark color. That specific color that they have, it's kind of like a teal color in those boxes is protected. So another individual would selling jewelry, for example, within the same color would probably infringe upon the Tiffany blue trademark. Same thing with UPS brown. So if you see other brown and gold or yellowish delivery trucks, that can be a possible infringement for UPS. And John Deere with tractors, those green and yellow tractors do represent John Deere specifically. So those are ways that these companies are able to provide trademark protection on their products. There's also scents, which is not a typical one, but you can get scent. The famous one would be Play-Doh. You have the Play-Doh, you smell it, it has a specific taste or smell for it, and that's protected. That's something that Play-Doh has protected as intellectual property. There's also this liquid power, which is a grape, groovy grape, which actually helps your exhaust smell like, exhaust fumes smell like grape, which goes back to a point of, it doesn't have to be commercially viable, but it does have to have that unique trademark for your product. So it is something that, you know, it has a specific trademark scent for it. Sounds are very popular and used a lot in cinematic universes. So Darth Vader, the breathing sound, that's a specific sound. And then even the lightsaber, when it pops up, you know, that specific lightsaber sound is a trademark that's protected. The NPC chime, it's a protected sound as well. And I'm sure you can think of some sounds that are protected through other movies and studios to try to protect their intellectual property. Trade dress is another form of trademarks, and this is where it helps protect the design of a specific product. You can even be like stores like Apple has specific design for their Apple stores, and that specific design is protected to trademark. Coca-Cola, the bottle itself, I think we shared earlier the root beer bottle that originally had a design patent that expired, and Coca-Cola actually got a trade dress trademark for the Coca-Cola bottle, and that's protected. Hershey has that specific drop chocolate texture trade dress is protected, and the Doc Martens with that specific style of luxury or fashion is protected as well. I'm going to briefly talk about copyrights. I know Mr. Ortiz is going to go over copyrights more in depth, but some of the things you definitely need to know is that there is a specific office for copyrights, which is the U.S. Copyright Office, which is what we call our sister agency. So if you wanted to register copyrights, you go through the U.S. Copyright Office. We do interchange, or we do, I would say, flirt with copyrights because it involves intellectual property. And we do have statute to advise the President of the United States in any intellectual property matters. And we actually help also with international policy affairs for copyrights as well. But we are involved in the copyright realm, and we do work a lot with the U.S. Copyright Office. But it is their jurisdiction for registration and education. So what is a copyright? Copyright is the legal protection for original works of authorship, including literary, dramatic, musical, artistic, and certain other intellectual works. So things that can be protected by copyrights are songs, books, movies, and sculptures, some examples. Additionally, you can get logos, which overlaps or can overlap with trademarks. Product design and packaging, which can overlap with trademarks as well. Advertising and promotional materials, instructional manuals, educational materials, software source code, which is a big one, you know, especially with app development and website development now. It's that typically falls under copyrights. Not to say you can't have a combination of copyrights, trademarks, trade secrets, and patents per se. So a lot of big companies will tend to protect it as best as possible, especially if there's a lot of value behind it. So trade secrets, this is the final form of intellectual property that we'll talk about. Do know a trade secret is something that you don't register. This is a form of due diligence that you do to protect a trade secret within commerce. So a lot of times you'll use a lot of legal documentation like NDAs, non-competes, confidentiality agreements to keep trade secrets a secret from everybody. So what is a trade secret? Basic definition, trade secret consists of information and can include a formula, pattern, compilation, program, device, method, technique, or process. To meet the most common definition of a trade secret, it must be commercially valuable information known only to a limited number of people, and reasonable steps must be taken to keep it a secret. So that's why I talk about you doing your due diligence. If you have a restaurant and you're giving your trade secrets of making the secret sauce to all your employees, you're not taking reasonable amount of steps to keep it a secret. You're giving that information out to the public. The famous trade secrets, you know, Coca-Cola is probably the biggest and the most famous trade secret out there. It says it's known to say that only about 2 or 3 people actually know the whole recipe of Coca-Cola, how to actually do it. You may know the ingredients, but you may not know the specific process, how to actually make Coca-Cola. KFC, we have the herbs and spices that is a trade secret. They're actually here, headquartered in the Dallas area, and we visited in the past, and even the chefs there that are working with the KFC products, they don't know exactly what goes into the herbs and spices. It just comes applied for them, packaged, and they apply it. Krispy Kreme donuts as well have a specific process, the way they make those fluffy donuts. And Google is a famous one because that one has a combination of all trade secrets, patents, trademarks, and copyrights. Just because the Google algorithm or the search algorithm is very popular, a lot of people want to know about it, so they try to protect it as best as possible with all forms of IP there. I do know that patents and trade secrets are opposite sides of the same coin. So in one, with patents, you get exclusive rights for a limited amount of time. You must disclose to make it an invention within your application, and there may be legal remedies should someone make or use or sell your invention without your permission. And any improvement in such matter as to distinguish it from your invention may be patentable, but it may infringe upon prior unexpired patent for the invention improved upon. So this is something that you're disclosing for limited exclusive rights for. And while trade secrets they last as long as it remains a secret. You may take the reasonable amount of steps. There may be legal remedies should someone steal your trade secret. But you may hear that a lot in like corporate espionage, companies stealing from each other, employees moving to another one and selling the trade secrets. Those are some of the examples that can fall under stealing some trade secrets. But it is completely legal on the trade secret side to someone to reverse engineer what you've already done. And that's why sometimes patents may be the best option. We never really incentivize or encourage individuals to go a certain way. We just try to educate you so you can make informative decisions going forward. This guidance and really understanding the process and each method really helps you understand what is best for your own venture. Now, you can definitely get IP counsel, and we recommend it actually for you to consult with one, because those expertise or those specialists can help you within that industry specifically and give you legal advice where we can't. So this is a good overview of the intellectual property that we talked about, gives you the differences and specifically how long they last. And we'll be sharing these slides with you guys so you definitely can reference it. I won't go over it, but it's a good overview and some of the overlap that you see within each of the IP. I'm gonna try to go over USPTO resources pretty quick so we can talk about Q&A and answer your questions. So the biggest resource that we provide is really our website. We have a lot of information throughout the year that we share with our subscribers. So definitely recommend if you want to stay abreast on intellectual property issues, subscribe to our newsletter within our regional office and then the headquarters office. And anything that we have coming up, such as trainings and news and updates, we can let you know. This is the number one way we communicate with the public. And we do have a specific inventor newsletter, so it's just a one-stop shop for all inventors and entrepreneurs. This intellectual property phase, or it's a niche within the entrepreneurship cycle. So this can fall under research and development typically, and it's really a specific focus. And if you're networking within inventors and entrepreneurs and IP counsel and specific group, you tend to get more information with not only resources, but subject matter expertise. And we talk about just the different cohorts, makers fairs that there is, inventors clubs, National Inventors Hall of Fame that we work with. There's definitely a lot of specific niche markets within the ecosystem, as we call it. We do have startup resources. We do work a lot with the U.S. Small Business Administration, Small Business Development Center, and other individuals within the government that provide public service. We're not a granting agency, so we actually do not fund any of these projects or services. We mainly help with education. And do know we're a fee-based agency, so we operate based off fees that we collect on patents and trademarks. One of the biggest reasons why we can't really get involved in giving any advice. And we also actually examine the patents and trademarks that you guys are applying for. So do know, like Jacob mentioned earlier, USPTO only covers the US and its territories. So if you wanted to get protection in Mexico or Europe or China or other countries, you have to go within their IP office. We do have some resources for that. We actually even have IP attachés around the world that can help you do commerce in different countries. So we can always connect you with that, and we can also help you fight counterfeits, which is a big issue. And then we can help you find federal funding, but through our partners that we work with, like the SBA and the SBA RSGTR program that they have, and then grants that the government may have available. And then we always recommend to engage with experts outside the USPTO. They can help you more with the commercialization side, which is something that we can't do. We can't help you with commercialization or enforcement. We can guide you and educate you to a certain degree, but that is responsibility of the entrepreneur or small business. So one of the more popular trainings that we have is what we call Path to a Patent. This 8-part series gives you a good overview of what patents are, how to do patent searching, and how to file for patents. So if you're interested in this, we definitely recommend. Even if you have IP counsel, it helps you understand the process better and it helps you spend your time more efficiently with your patent attorney, which you will find that they can be costly because they are subject matter experts within their background. So they do have to have technical backgrounds. Typically engineers will be background, and then they also have to have the law degree and understand the law side of it. We do have a 1-800 hotline for Inventors Assistance Center for inventors, specifically in the patent world. So any basic questions that you may have in the process, feel free to give them a call and they can help you. The 1-800 hotline that we have on Monday through Friday from 8 a.m. to 8 p.m. Eastern, except federal holidays. We do have a patent public search tool. This helps you with doing your due diligence, making sure that you're not infringing upon other prior art that's already out there. And it also helps you reverse engineer, especially if you're looking to see what's already out there and improve upon a certain piece of art. The patent public search tool can help you with that. And it's available online. One of the good things is that we're able to advance it from the specific centers that we had before. Now anybody can do it with a web browser. Trademark basic boot camps is the most popular training that we have, and this one will walk you through the basics of trademarks and how to actually register trademarks as well. Our trademarks outreach team handles this one, and it's specifically trademark attorneys that actually do examination for the USPTO, teaching you how to do it on your own. And they also have a 1-800 hotline with an email that you can actually access in case you have any specific questions on filing or the process itself. Remember, again, no legal advice can be given, but support is there. Do know that individuals such as small businesses and micro entities do receive micro entity status or small business status that can help you get 60 to 80% reduction on patent fees. So the USPTO fees that we have are pretty standard. You can look them up online at uspto.gov/fees. But if you're a small business or micro entity, you can actually fall under the 60 to 80% reduction. And that's based on your gross income and higher institution level. So most small businesses will be able to qualify. So do know that we can assist you with those. Most of the costs actually come from drafting fees, from getting a professional, like a legal attorney, like a patent attorney or patent agent, to help you with the drafting side of it. And we do try to provide resources on that. So one of the biggest one is USPTO's Patent Pro Bono program. It's where you get free legal assistance from practicing attorneys to help you with the drafting of a patent application. So each region has its own territory. It may not be within your state itself, but you do have coverage. Well, for you guys, it's actually in Colorado. But you do have to meet requirement, so income, knowledge, and invention. So basically that would mean 300 to 400% below federal poverty guidelines, a knowledge check, which is taking a training within the USPTO website, and invention, which is feasible, which a lot of times will be requirement based on a provisional application. But they do want to make sure it's something that's viable. So this is the Patent Pro Bono program for New Mexico, which is Mi Casa Resource Center, which is in Colorado. But like I said, it does cover the state of New Mexico as well. We do have law school clinics around the nation as well, and they're another form of pro bono. This is where second and third year law school students under a clinic supervisor can help you with drafting fees or drafting applications. So the individuals themselves, the students learn while they're going to school under the clinic supervisor, and you get that pro bono service that you're looking for. And this can be for trademarks and for patents. We have several schools around the nation that don't have jurisdiction. I think it's about 19 of them that can go outside of Texas or Virginia or wherever they're from. So do know that there isn't a specific one in New Mexico right now, but the other ones can be able to assist. We do have a PTAP pro bono program, and this is very similar to the patent pro bono program. It helps you with ex parte appeals. So it's very similar in case you run through any difficulties with ex parte appeals and challenges. Would be on behalf of the PTAP, you can apply for the patent pro bono program. The PTRC is the last resource I'll talk about, which are patent and trademark resource centers, where this is where we educate community librarians to help you with patent and trademark public searching. So it's always the first step, once you have an idea and you want to protect it, is doing your due diligence, doing your research behind that patent or trademark that you want to go after. But just, we continue to expand these services. There is one in New Mexico, and these librarians are trained through USPTO to help you do those patent and trademark searching. And then the last thing, follow us on social media. We stay very active. We try to make IP fun, try to put out institutional facts and historical facts on intellectual property so people can understand it more. The way we've noticed, the way people understand it more, the more likely they are to use it and protect it. So the more people feel comfortable with intellectual property, they tend to protect it, which helps us since we're a fee-based agency at the end of the day. This is our information. Feel free to contact us. We can always have one-on-ones with you and talk about your specific venture or problem or inquiries further. And that's it for us. And what's going on with the questions now?
Thank you, Reynaldo. That was very good. We do have some questions. We have, can an individual file a copyright on written material without going through an attorney for every copyright?
I don't know. We want to give this one to Luis, and Luis is covering the copyrights.
Luis, you want to join us and then
Yeah,
answer?
sure.
A little preview of your presentation.
Yeah, it's in my presentation, but honestly, I've encouraged some clients to just file for themselves. It's not a really difficult process. You can do it online. You need to fill out an application, provide a copy of the work, and pay the fee. The real work comes in when there's an infringement or there's licensing involved with the copyrighted work. But unlike patent, which is more involved, and then trademark, which is kind of in between, copyright is probably the easiest thing to do pro bono. So we'll talk about that in the presentation, though. But the answer is yes.
Good.
And then we have another question. It says, I have a few original songs written that I would like to copyright the lyrics to the song. What do you suggest I do?
Want to go for that one, Lisa?
Sure. I would suggest you register it. Now, copyright, it's going into my presentation a little bit. It's automatic. As soon as you create the work, you automatically have a copyright in that work. Unlike, getting a patent for an invention, you don't automatically have patent rights until you actually go through the process. But for copyright, there's common law copyright protection, but there's benefits to actually registering the work, such as statutory damages, attorney's fees, things like that kick in that make it worthwhile to register the work. And for your music, you're talking about an application fee that's under $100 for registering that. And so it's worthwhile to get that registration if you think it's something that you want to exploit commercially.
I would say, working with the U.S. Copyright Office, they do have a lot of educational content as well that can help you walk through the steps, similar to what we have for patent and trademark basic boot camps. Those will help you walk through the process in case you have any specific issues. But Going through like the registration of copyrights, trademarks, and patents, the easiest one to do would be the copyright one, and then trademarks, and then patents. That's typically the order right there on how hard it is to actually do the applications themselves.
I have a question. So, you talked about trade dress, and that's a form of a trademark. And do you register a trade dress, and what's the process?
So the trade dress would be something that you will register. For the non-traditional trademarks, you do have to have a history and be able to show source identification. So keep that into consideration. It's not, I can't just really start a business today and then start trademarking the color that I just invented, because it doesn't, there's no source identification for consumers. So you always have to have that specific consumer protection right there. It's like it has to be recognizable to your public. So just keep that into consideration. And trade dress is one of them. So like the Doc Martens themselves, that's something that people can recognize as a specific source identifier the way it is. So it is it's not traditional. It's not as easy as it may seem. Like sometimes I think we may present it as a little bit easier than what it is, but that's why we always do recommend to consult with an attorney.
Oh, okay. We have another question. What is the meaning of non-obvious in relation to a utility patent?
Okay.
Want to go on that one, Jacob?
I'll take a stab at it. So that's a great question. So if you are interested in learning more about what is considered as a non-obvious, I would ask you to look at the 35 US Code 103. And this is a particular section of the manual patent examiner's procedure where our examiners are actively reviewing your case, your patent application with respect to the research they have found in terms of form of what is considered to be a prior art, anything that kind of dates before your effective filing date of your case. So in that, what is considered as a non-obvious is here's a sort of a random example that I've been giving to people. I hope this is helpful. So number 2 pencil actually has been patented way back when. So at that time, how it became a patent is the fact that first, on one hand, you had a writing utensil, a lead pencil, but no one actually had thought of, and there was also an eraser too. At that time, no one really came up with this idea that by using a metal media that you could actually have on one end of the writing utensil to add an eraser by using this sort of an attachment member. So thus you have this sort of a number 2 pencil. So at that sort of analysis, if I was, and our examiners are reviewing that case, essentially what they will find is if your application is essentially number 2 pencil, a lead pencil with an attachable media with an eraser, all 3 components into one. But yet at that time, the writing utensil existed. Eraser also existed. So what the patent examiners would do is to really look at those 2 prior arts, for example, and be able to determine, is this something that one in ordinary skill in the art to be able to combine eraser on top of the writing utensil. In that particular example that I'm kind of giving you, that's probably not possible without another teaching or prior art that would suggest attachment member of writing utensil to another eraser in different forms or shape and the like. If there's such teaching, then perhaps, maybe, at that time, that number 2 pencil idea may be considered as obvious. But I would say, like I said, mentioned before, it was like we know the answer. Number 2 pencil was patented, right? So at that time, when the examiner probably reviewed these cases, reviewed this particular case, they came across probably these relevant prior arts, but never came across a fact that actually would allow these 2 features to be combined. So hopefully that's helpful when it comes to like obviousness tests or what is considered as obvious or non-obvious. But if that didn't make sense, please look into 35 USC 103 and read more into it. I love this question, but it's not a really easy way to like easy thing to kind of explain.
I have another question, and it's regarding software. And I know you, software is mostly copyrighted, but when can it be patented? Can it be patented?
Oh yeah,
So
that's
I'll start it. You wanna go, Jacob?
that's another great question. So I think absolutely correct. Software code in itself, you should definitely go towards the copyright protection if that's something that you want. But as long as that code is somehow connected to what's considered to be a tangible media and it has specific outputs. For example, like you are looking at your computer and then there's softwares and apps that you use and it has certain function or output, right? When that happens, you can in fact, as an example, obviously, you can in fact get a patent on that particular idea. So just on the surface, code itself, I would kind of lean towards copyright protection. I don't know, Louis, anything that you want to add respect to that area, but certainly there is a pathway forward for getting a patent on the code plus, tangible media and more.
Yeah, I would just say it's a little more difficult these days since the Alice decision about 10 years back from the Supreme Court to get software patents, but it's still totally doable. You just have to be a little more specific as to how the software is operating within a computer, and how it enhances that operation. It can't just be crunching numbers and spitting out an output like a financial program. There's got to be a little bit more involved. Maybe there's sensors involved. Maybe there's some output that's robotic or whatever. So the more of those kind of things that are going on with the software, the better for patent claims to be allowed.
Yeah, Louis, thanks for mentioning that court case. I do want to say that USPTO website, www.uspto.gov, if you go there and then search for the phrase subject matter eligibility, we do have a number of examples where you could, we give you example as to what, specifically talking about the software codes and what Louis is talking about. We do give some example as to what that claim may look like and pathway forward for obtaining a patent from the USPTO. So I would strongly suggest for you to look at that area and then take a look at some of the examples that we're showing you. Okay.
Yeah, and I would just to add on that one, typically when they go after a patent on the software side, they do it through business methods. So in case you're interested, that's a common practice, I would say. And I did put that link in there on the Business Methods Technology Center within USPTO, so you all can learn more in the chat itself. The next question, I think I'll take it, Steffi, which is how many differences from the older, actually no, is a trademark registration done before or after opening an LLC? So it can be done before, but it can't be awarded, the certificate can't be awarded till it's in commerce. That is something that a trademark examining attorney needs to verify that it's in commerce itself. But they do give you leeway of 6 months to do it, but you can't get the registration of the trademark until it's in commerce. So that's for Camille there.
What's the status for intent to use and in use on the application?
Intent.
Yeah.
Yeah, I mean, it has to, the statute pretty much says it has to be in commerce to use, but they do give you that 6 month, they can give you up to 6 months for application beforehand. So like if you're gonna open up a business, you can do 6 months beforehand, but they won't be able to give you the actual registration until it's in commerce. That is something for trademarks. So when I went over to earlier and I did the IP overview, the timelines for trademarks, it's good, they're good until they're what we call abandoned, so they're no longer in commerce or use. So like, for example, Coca-Cola, they have the trademarks 500 years from now, and they're still in commerce. That trademark is still valid. That's one of the reasons why I kind of mentioned how trademarks can be very powerful they can supersede a lot of life that copyrights can't, and patents, for example.
Can I jump in there, Reynaldo? So,
Yeah, go ahead, Chris.
so trademarks can be awarded to the individual and to the business entity, right?
The way I'll have, I don't know if Jacob or Luis want to answer that one, but it's pretty much the way it is structured on the application, from my understanding.
I mean, ownership could be in an
Mhm.
individual, but use has to be associated with a business.
Mhm.
Public. So, like the owner could license it to his business perhaps, and then it's the license that drives usage of that trademark. But it does have to actually be used, and then it also has to be policed. Should somebody be infringing on those rights? So in order to keep a trademark, you could actually lose it by allowing people to infringe it without policing your mark or how it's used as a licensor.
I think, Chris, you're asking like a sole proprietorship, right? If they can have a trademark.
What I was just thinking forward, if I wanted to establish a business and I wanted a trademark for that business, I might want to put it, might want to award that to the business entity if I plan to sell that business later. Because you're not going to buy Walmart, right? If you can't use the name Walmart or the logo for Walmart.
I would say typically yes, but you do have to, and this is where like legal negotiations come into play. Sometimes companies can structure a business sale just on like physical assets and say like, you know what, I'm gonna keep the IP rights on this, so I'm gonna keep copyrights, trademarks, but I'm gonna sell you all the furniture and buildings. So, but yeah, typically I would say yes, Chris, but it does I always give you the lawyer answer, right? It depends what the contract actually says, because you can, like Luis was saying, you can be specific on the licensing rights, like who's keeping what at what property. Because at the end of the day, like Jacob mentioned on intellectual property, they're assets, and you can take them away specifically through licensing or just contracts.
Perfect. That's exactly what I was thinking of, the balance sheet. And if you want an asset to be on the balance sheet, it has to be owned by the business, not the individual.
We have 2 more questions in the Q&A.
So Julie O'Hare says, how many differences from the older already patented item should my design and or usage be? You understand that one, Jacob? I think just trying to go more to like significant changes, like.
Yeah, Julie, feel free to kind of expand on that. I do want to get it right in terms of exactly what you are asking here, but if I may have to go with Ray's interpretation in terms of the degree of the difference between like what is known at the time versus what you could get a patent on. So I
Okay,
would,
so I have a photo, I have a picture. So this is currently already on the market.
okay,
I don't know if you can see this. And the width of these is different than what my product will be. And do you see how
Ju-
large it is?
Julie, by the way, we are unable to see what you're sharing.
Oh, I'm sorry. Okay. Yeah, so my product is, I'm gonna have a different size. It's gonna have a very specific millimeters of width.
Mhm.
That's not on the other original patented item. Some of it is similar, so I'm just trying to, mine is more user-friendly for a small, very, very small product.
Got-
And easy to hold in your hand. It's, it has a different application, I guess you could say. Well, similar application, but I feel like the older design is more just kind of generic and mine is more specific.
Right. Well, thank you, Julie. Thanks for unmuting your mic and clarifying your question there. So I hate to say this, but the answer is going to be depends. I do think that I would just emphasize the word improvement. So did you make any improvements over the existing innovation. Obviously, I'm not sure exactly what you're sharing, but I would tell you that I don't want to discourage you, but but at the same time, I have to be realistic in terms of changing the size of a widget to optimizing changing the color. Examiners actually do have a ways under the 35 USC 103, US Code 103. Not only they can go out and find facts in terms of what is known at the time, but they could also rely on top of all that, they could rely on previously decided case laws. So on that topic, I can tell you that there has been some cases that's been said about the different sizes or different maybe changing the color as an example, optimizing what was known at the time to something else. So, but that analysis really needs to be in that examination process, really needs to match what the applicant is trying to do. So my answer is depends. I'm sorry that I'm giving you this answer. However, if you want to connect with Ray and myself separately as maybe a one-on-one consultation after the presentation, maybe later next week or something, we'll be more than happy to do that to kind of go over your case. Okay.
Okay.
Good,
Okay.
good lively audience here, Steffi.
That's so good. Okay, we need to start on our second presentation, and we'll look to see if there was other questions that weren't answered. But I think we did have a bunch.
Yeah, just send us an email in case you guys want to talk, and we can definitely make sure to answer your inquiries. Some of it, like I said, it may be legal advice, and that's something that we can't do. But we'll try to educate you as best as possible.
Reynaldo and Jacob, thank you for your presentation. It was well received by everybody, and I'm so glad we still have all our attendees here. And so now I would like to introduce Luis Ortiz, and he will start with his presentation.
Okay, and everybody see the presentation at this point?
Yes.
Okay. All right, well, thank you for having me today to present. Mine will be specifically on copyright and a little about the firm. We're based in New Mexico. Actually, it's Albuquerque. I was born and raised in Santa Fe, but you know, we have a strong connection there. And we service kind of Southwest clients as well as national clients on intellectual property matters. And we started the firm in 2001 in Dallas, Texas, and have been in New Mexico since 2003. And that's a little bit about our firm. Here's the agenda for today. We're going to do an overview of copyrights. We're going to talk about copyright registration requirements, talk a little about ownership issues and how third-party collaborations can affect rights. We'll talk a little about copyright infringement. We'll talk about what kind of damages you can get for copyright infringement should your copyright be infringed by another person or company. And then we'll have some question and answer period and then close. So let's do a little overview of copyrights. First of all, I just have a little IP overview slide. Copyrights is one of the 4 rights that has already been well covered by our other presenters. You know, copyrights protect the original forms of expression, not the ideas like a patent would, or but copyright could fall under the same area as trade secret, where you know inventions and copyrightable subject matter could be held as a trade secret. So there's some overlap in some of the rights here. Copyrights last for the author's life of 70 years, or if it's a company, then it's 90 years from publication, or 120 years from conception. And what is the purpose of IP? And I do this more generally, like patents, trade secrets, copyrights, whatever, what have you. But the intent is copyright for this presentation. It's just to protect against unauthorized copying by others. It helps establish a barrier to entry in the marketplace. So if you have a business and you're currently you know, selling goods or services, it'll help you put this barrier because you have a registration or protection of your IP. So if somebody's copying that, you can try to keep them from doing so. It also enables your market expansion should you want to go into other areas with that same protection that you have over your IP. Also helps for fundraising. Sometimes you need to find funding, and usually the angel investors or the VCs or whoever's going to invest in you, they're looking for an IP position. You know, what kind of intellectual property do you have? The barriers to entry again. And it also can provide you some leverage when you're doing contracts with others, that you're coming to the table with some protection, may give you some better terms in a contract. And finally, business valuation. Should you want to be acquired or merge or do something like that, again, intellectual property is part of the portfolio that's going to be looked at during due diligence. And at the end of the day, you do all this for wealth creation. At the end of the day, normally most people or companies want to get bigger and make more money. As far as copyrights go, these are the two symbols that are typically used, copyright or P for phonographs. And what it grants you is an exclusive legal right to reproduce, publish, sell, or distribute the matter and form of something. And, you know, this has already gone over a little bit, but it's like literary works, musical works, artistic works, software, performances, mask works on semiconductor designs. There's a variety of things that are protectable. Architectural works, for example, floor plans for a building or a house. And what it's giving you is the rights to reproduce, prepare derivative works, distribute copies to the public, perform the works publicly, and display the works publicly. The basis for this, again, is the United States Constitution. Our founders, founding fathers, they realized this was important enough to include in the Constitution in Article 1, Section 8, Clause 8. And it's called the Copyright Clause as well as the Patent Clause. And it's to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So as you can see, copyright and patents are right in the beginning documents for this country. And the rules are codified under Title 17 of the Code of Federal Regulations, if anybody wants to look into all the various rules and regulations for copyright. And what is a copyrightable work? Well, it's original works of authorship fixed in any tangible medium of expression, according to the United States Code. On the left column is copyrightable works, literary works, musical works, dramatic works, the list goes on, sound recordings, architectural works, semiconductor mask works, software. So these are the kind of things that you would consider copyrightable, and you would want to register with the U.S. Copyright Office. On the right are things that aren't copyrightable, but most of those are still protectable. Maybe not under copyright, but under patent law, you know, as a utility patent perhaps. So ideas, procedures, processes, systems, those kind of things. Now, principles and discoveries aren't usually patentable subject matter. It just depends on what it's mixed in with. But this gives you an example of what is and what is not copyrightable. What are the registration requirements? So to register your copyright, we talked a little about that in the last presentation. You can do it online at copyright.gov. It's under the Library of Congress, the Copyright Office, and it's a pretty straightforward process. You have to fill out a proper application. Again, you can do it online, or you can actually submit forms. Forms are a little more expensive though. You know, it's cheaper to do it online. Then you have to deposit a copy or copies of the work with the application. A copy if it's already been published, a couple of copies if it hasn't been published yet. And then you have to pay the applicable fee. It's as low as $45 for one work, and get as high as $125 if there's more than one work, or you know, if it's a database loaded with images or songs, or whatever, that could be up to $500 and $800. There's kind of a range, but for the most part, most people are going to experience a cost of $45 to $125. And the different types of forms that are used or selections online are TX for literary works. These are like, you know, manuscripts, books, things like that, manuals, what have you. VA is for visual arts. So this could be movies, it could be commercials, things like that. PAs for performing arts, so actual plays or things of that nature, performances. And then SRs for sound recordings, and then SCs for serial work. So a serial work would be like there's an episode after an episode after an episode in maybe a series, like a movie or something. So what is required? What is the copyright looking for when they examine your application? Well, they're looking for originality of the work. Unlike patent law, you don't have to have something that's brand new. You know, that's novel, not obvious, all those tests. It just has to be independently created by an author and has to demonstrate a minimal degree of creativity. So it's not, again, it's not about being novel, but it cannot originate from another source. It has to be an author's own efforts. You can be an author or co-authors. It doesn't have to just be a single author, but collectively they've come up with this work. It's a pretty low bar. It just has to show a modicum of originality. So again, it cannot be copied from another work in total, but there is this derivative work thing. Sometimes you can take something and create a derivative work of it. Doesn't mean you have rights to the underlying work. You can still be an infringer if you don't get permission. But a derivative work is sort of like an improvement on the original work. There's no requirement the work be novel, I said that already, or imaginative or inventive. Now, notice, I said that you're automatically have copyright protection when you create the work, even if you haven't, tried to register it yet. But there is a notice that is always used or should be used on your copyrighted work or on your work, even if it hasn't been registered and after it's been registered. An example of that is down below. You use the copyright symbol, or you say copyright, or abbreviate copyright. You use the date of first publication and then the owner's name. So like for this presentation today, it's being published to you as I present it to you. And so I would have an automatic copyright in this, even though I haven't registered it. And there's my notice. Let's see. Oops. What is the term of copyright? Well, it begins automatically, like I said, as soon as it's created. But formal registration does provide legal benefits. The legal benefits you get by registering your copyright are statutory damages and the right to attorney's fees and costs. You don't automatically get that if you're just relying on your common law trademark rights without registration. And post 1977, under the latest Copyright Act, the duration is life of the author plus 70 years. So a person's estate could have those rights even after you pass for 70 more years. If the company owns it because it was a work made for hire, then that means employees in the company made it for the company. Then the company can have it for 95 years from the first publication of it or 120 years from its creation. What is a work for hire? Well, a work for hire is a work that's owned by the employer or the customer. And it's because they paid someone, an employee, for the purpose of creating the work. Maybe these are programmers in your company or content creators. So any work they do while they're under salary is considered a work for hire. You can sometimes hire contractors or collaborate with third parties, and then that gets a little bit stickier. It's not automatic and should require some sort of agreement or assignment from the independent contractors. And volunteers is also an area. They're not necessarily an employee, but it might create something for your company. So it might be important to try to get those rights locked down if this is the kind of third-party activity you're allowing in the creation process in your entity. So when you buy a phonorecord, you have the rights to that one copy, but you don't have rights to duplicate it and distribute copies of that copy. And so that's the thing about copyright, is it's distinct from ownership in the material object. You can transfer the ownership of the material object, but it doesn't grant you rights. Now, some people will get a painting, maybe want to duplicate it and make prints, distribute prints. They don't have that right. Only the original copyright owner has those rights to make prints of the work. Now, more on ownership issues and joint collaborations. So IP rights can be compromised if relationships with non-employees are not set forth in writing. I kind of suggested that in the last few slides. If a non-employee designer or contractor is working with you, it's best to have an agreement defining the scope and delivery and ownership for the works. Sometimes you might jointly collaborate with another company. Two companies come together, they have different coders working on software, and their coders are partially writing portions of the software code. So how is this going to be dealt with? That should be ironed out. Preferably, it should be ironed out at the beginning of the collaboration, so that it's well known what's going to happen with the rights, who's going to own what, are they going to jointly own it, how are they going to commercialize it? And is there any background IP that one contractor might have that is going to be used that needs to be licensed to the other entity? Now, again, I said employees can be a significant contributor, which you have to ask yourself, are the employees hired to create? Are they, did you hire them to be software developers? Is it likely they may create IP? Has the employee been briefed on duties with respect to securing the company IP and their confidentiality obligations? Are employees contractually obligated to assign IP if they create, to assign it to the company or to cooperate in assisting a company with securing its IP? These are good things to iron out when you bring people onto the role of creating IP for you in your company, whether employees or contractors. These obligations should be ironed out. Now, with joint collaborations, I can't mention this, how IP is to be shared if it's jointly developed. If the work is by a contractor, are the rights to be assigned? Certainly that would be what I would want if they're developing code for me. Are they going to keep it confidential? Are they going to disclose any conflicts they might have before joining the company or writing the code? And are they going to agree to cooperate in securing the rights? Like with inventors, you want to make sure that's tied down and that they're going to help you actually obtain the patents and apply for the patents by cooperating to sign agreements, things like that. Same with copyright software, they got to support you in protecting that IP, hopefully. Now, there's also public and unprotected disclosures. If you're writing code, certainly you don't want any of that to get out the door. And especially if you plan to keep any of this as a trade secret, you have to make sure that whoever's participating in your company as an employee or contractor are careful about disclosure of it. It should be done under an NDA or confidential disclosure agreement or non-disclosure agreement, preferably, so you can control the distribution of the data. And you also want to be careful to avoid contamination of organic IP, that's your IP that you're creating, with third-party info. This happens a lot when employees change jobs. They might be writing code for another company. They come to your company. Now they're going to write code for you, and they bring some of the ideas from another company. That can contaminate your software, your organic IP that you're trying to create, because the third-party information is getting intertwined with it. So you got to be careful that you in-brief your employees and out-brief them when they leave about their IP obligations. You could also encumber the IP. How's that? That means there's other rights involved in them. If you're getting government grant funding, then the government gets a right to carry out, a license to carry out the invention, whether it's a software or patent form, on behalf of the government, and they can do it with other parties. It doesn't extend to commercial use, but if your only use for your intellectual property is government, this could be a problem. So what's the solution to that? Sometimes we walk into an SBIR or a government contract, we already have IP. To the extent it can already be registered or patents filed on it, it should be done before the contract is signed and before the work begins, because then you've established this background IP that can't go forward and be licensed by the government to other contractors. You could also have encumbrances when it comes to university IP. You may license IP from the university software or inventions. But they might limit you on the field of use, geography, and term, and the licenses must be renewed at a cost of license fees, including royalties, reimbursement of IP costs. So it can be kind of costly. A solution there is to make sure, again, if you have IP before licensing the university IP, protect it. But if you're creating IP that is different from the IP you're licensing in, then you've got to create that organic IP on behalf of the company alone and license, protect it so that it doesn't kind of get mixed in with the university IP that you're licensing, if that's even possible. Now infringement. So infringement is use of a copyrighted work without the copyright holder's permission or legal authorization. The same rights you get as a copyright holder when you register your work are the rights that somebody else should not be doing, which is reproduction, distribution, display, performance, or creating derivative works without permission to the underlying work. So these are the kind of things, activities that cause infringement. To have infringement, you must show access, that there was access to enable the copying of the original work, plus substantial similarity. There has to be a similarity between the original elements of the copyrighted work and the alleged infringing work, or they are strikingly similar. So I have some examples of that. There's a case that we've worked on where a jewelry designer and store owner in Santa Fe copyrighted this work in 2009 on the left. And then a few years later, a competitor a block or two away in the plaza in Santa Fe began sales of the ring you see on the right around 2011. Now, I mean, I'll let you guys look at these and can decide for yourself, is there a substantial similarity here or not? And so with this kind of question usually goes to the jury. This isn't as simple as a judge being able to, make the case go away under summary judgment, because there is some similarity. Now here's another, this is a direct infringement of one jewelry maker to another's designs. That's the allegation. But there's also a contributory infringement claim against the catalog owner on the right that publishes pages for different artisans. There could be furniture, clothing, just different customers, like 30 to 40 customers publish their ads in this book, this catalog. Well, it just so happens that this party's jewelry is being published on a page, and you can see the necklace and the ring are kind of similar maybe to the copyrighted designs on the left. The publication of the catalog was in 2014, and the copyrighted work, it was copyrighted in 2009. So is there substantial similarity? Again, that would be a jury question, and you're sitting in kind of the shoes of the jury right now, trying to figure out if you think so. But let's throw a little wrench in all of this. Let's look at something that predates the 2009 copyright. Here's some jewelry that was sold to the public in the 1980s. So now that you see this work that has that same zigzag design and inlay features, do you still think that maybe that's a substantial similarity in design? Or do you think that this kind of defeats that copyright? So these are the kind of questions that go to a jury after a lengthy trial on copyright infringement. All right. Now, since the theme of this year's presentation is music, I thought I'd go a little bit into that. In the music industry, copyright infringement occurs when someone uses a song or part of a song without obtaining permission. This happens a lot. I think the artists that are most notable for this kind of conduct are the rap music artists. And it's because they sample songs from other creators. They may use a melody or chord or progression or a similar rhythm. And so there's been a lot of copyright allegations back and forth from different artists to the rap artists or vice versa, for using parts of their song. So I've got a couple of examples. or one example actually, of reusing a part of a song, and I'll let you, the jury, decide whether there's similarity. Bear with me on the commercial. I got this from YouTube.
What did you bring back from your last trip? A taste for dumplings, a bit of local art, a poncho story, a new wake-up call. Everywhere you go with Marriott Bonvoy shapes you, making you the greatest souvenir of all.
It let me skip the ad earlier last time. Sorry about that. There we go. Right, now here's Vanilla Ice and his Ice Ice Baby, which was published after that song.
You know, we can't hear them, and that's the setting.
Yeah, hey,
On Zoom, on Zoom.
take it.
There it is.
Oh, you couldn't hear it?
No, we had problems with that, it's a setting on Zoom.
Oh, okay.
So, sorry
Did you
about
want me
that.
to redo that, or?
We could just let you go ahead and talk about
Okay, let's just talk about it. So anyways, basically that was a sample of Queens Under Pressure by Ice Ice, Vanilla Ice on Ice Ice Baby. And of course, a patent infringement lawsuit was filed and they settled. And eventually Vanilla Ice bought the rights to it for $4 million. But it's those kind of things like Blurred Lines, Robin Thicke, and the last time with Marvin Gaye was another controversy. The Marvin Gaye estate sued Robin Thicke for the copyright infringement. Another popular one is the Rolling Stones suing the Verve for Bittersweet Symphony. So these are examples of music that has been infringed. Now, there is a fair use exception to any kind of copyright infringement that I thought was worth bringing up. There is some exception where you can get away with copying material, but it has to be for very specific purposes, like criticism, commentary, news reporting, teaching, scholarship. You can use it in like for school or research. And the key aspects that are looked at to determine if it's a fair use is it for limited use, or is it for a specific purpose like those I mentioned? What was the effect of use on the marketplace for the copyright holder? And did it negatively impact the copyright holder? And also there can be no profit. There has to be a non-profit use of it. If you're using it and you're making money on it, then that's not really a fair use exception. All right, finally we get into damages. This is the important stuff. If your copyright's being infringed and you can prove it, what would you get for that? So there's non-statutory actual damages. This is where you have to like prove you have lost sales and profits and lost licensing revenue. You got to prove that the other side has taken some of that from you and the profiteering on your copyright. But this is an unregistered copyright. So you don't, although you can ask for costs and attorney's fees, it's not guaranteed you will get those. So the reason why it's so important to register your copyrights for your works is so you can get statutory damages, because these are guaranteed. If you should prove the infringement, you have a minimum of 750 to up to 30K per work infringed. And so that can add up as if it's many times and many works that are being infringed. And then costs and attorney's fees are part of that. And if you're a willful infringer, it goes really up there on damages per work, 150K. Costs and attorney's fees and potentially imprisonment of up to 5 years and 250K per offense if it's just an outright purposeful copying and you know the infringer didn't care. They could face actual prison time. So that's why it's worth registering your works for the Copyright Office. What's considered in determining damages: the revenue lost as a result of the infringement, the profits earned by the infringer, the need to deter future infringement. Like if you don't chase the first infringer, then others might infringe. So you have to, deter that activity by others. You need to penalize the infringer to send that message. And then to look at circumstances of the infringement and whether it was intentional or willful. And wow, that terminates that's the end of my presentation. We can go into questions now. If there are any.
I have some questions. We don't have any in the Q&A yet, but
Okay.
what was the P with the circle? What was
That's
that
for, that's for phono records.
photo records?
Records, yeah, or CDs, or for music.
Okay, okay.
Usually C's everybody uses C, but the P has been used for those.
And then what happens when a copyright goes into public domain and you want to use it? Does that go under fair use?
Well, once its copyright has expired, and I think that just recently happened, didn't it, last year with one of the Disney characters,
Mickey Mouse?
first Mickey Mouse. Now anybody can use that first Mickey Mouse because the copyright expired.
Now, can they make money on it?
Well, I mean, they could try, I guess, I mean, to the extent that they use it in association with their business or whatever. I don't know how they would make money on it, because Disney still dominates that, but theoretically they could, I guess.
And then, so if it's in public domain, and then they make a derivative of it, right? Like maybe somebody puts a picture with a poem on it or something like that. It's a new thing. Are you able to copyright that?
You can register for the copyright on that, but you still might run into a problem where you're the infringer of the underlying work.
Okay.
If that's not the public domain. Now, if this Mickey Mouse is in the public domain and you're using it as part of some other art, you're not going to get in that trouble. But the newer Mickey Mouses or characters that are still copyrighted, if you try to do some derivative work, introduce it into your artwork or whatever, that could be a problem.
Okay, I have a question from, oh, we do have questions. Okay, cool. Okay, so what is the best source to research whether a copyright is still in effect on an old song?
Well, so it depends on the age of the song. There's some changes in how long a copyright lasts for before January 1st, 1978, and then post January 1st, 1978. I gave you those time periods of how long you can keep the registration. It doesn't expire, like the life of the author plus 70 years. That's quite a long time, right? But before that date, it was a bit shorter, but I think it's still, let's say there's a song from the 40s. I don't remember the actual time period, but it's a lot shorter. They might be expiring at this point. It would just take a little research, but the Library of Congress or the Copyright Office does have a database that's searchable. So you can search for works there. Like if you have the title of the song, you can see when it was registered. If it was pre-1978, then it's going to be the shorter time period. And it might already be expired if it's old. If it's the 40s or 50s album or a 30s album or music, it could be a piece that's already in the public domain.
So do you check to see if the artist is still alive and then like add 70 years to it or anything like that?
That's what you would do if there's something you're interested in and using. If it's still in effect, you got to have permission. You want to ask for permission. Maybe you have to pay a small license fee. Unless it's a very popular song, then it's gonna be a large license fee. But if it's expired, then it's free for everybody to use once it falls into the public domain. But it would just depend on the year, that the artist died and how many years are left on the copyright, or if it was a company that owned it.
Okay, we have another question. It says, is there any risk to apply for a patent or copyright?
There's, the only risk, let's say on a patent filing is that you don't get the patent, but you've had to disclose it to the patent office, so it becomes public information after 18 months when it's published. Because when you file for a patent, after 18 months, it's published as an application. It looks very much like a patent, but it's not a patent yet. But at 18 months, that's part of the deal, is that it publishes and goes into the public domain for everyone to benefit from. And then if you get the patent, then they have to come to you for a license. So, if you don't get the patent, then everybody got the idea, and you share that idea with the public. But if it's something that can be kept as a trade secret, then you don't file for a patent. But the problem is, how long can you keep it a trade secret? Is an employee going to leak that out when they leave, or is a third party going to be able to reverse engineer what you have, and then you don't have a patent on it, so now it's kind of fallen into the public domain that way. So it's kind of got to weigh out the costs and benefits there, but I still think it's worth filing a patent to get that 20 years of protection, that barrier to entry for 20 years, if it's something that is protectable, That's something you have to determine based on prior art searches and things like that. Like copyright, I mean, as I said, you already get a copyright as soon as you create it. Whether you register or not is, and when you register it is up to you. But certainly that's, if it's something that's software working in the background that nobody can see and you can keep it a trade secret, then you probably wouldn't want to register it.
Okay, I have a couple of questions, and it says, I make jewelry. How do I copyright my earrings?
So you'll use the go online and you will select VA for visual arts. You would fill out the application, and then you will submit a photograph of your earrings, just like the photographs I showed you of that first jewelry maker's earrings. Those were submitted to the Copyright Office, and then you pay your fee, probably $45, and then you probably wait about 4 to 6 months to hear back from the Copyright Office. And if they're original, you'll probably get the copyright registration.
Okay, and then also, can I copyright a collection of work?
Yes, you can do it as a collection.
Okay,
So you
and
can put pieces together and call it a collection, give the collection a name, and you can submit all those as a collection, all the photographs.
okay, and then it says, I know my items can be modeled and duplicated, but I want to avoid it. So that's what the second one.
Okay.
Yeah, there it is. It says her collection work, and then I know my items can be modeled and duplicated, but I want to avoid it.
Yeah, you don't want it to be copied. So yeah, it's really inexpensive. I would register copyright protection on your jewelry. And should it be knocked off by someone, you can always notify them, and maybe they'll stop, or have them license your jewelry design. I mean, you have to take steps afterwards if you detect infringement.
Then we have another one. It says, I am working with a music library and I sign musical tracks to the library. Do I copyright my tracks? They tell you not to because they want to own the master.
So is there an arrangement in that deal with this entity that they own the copyright and they'll file for the copyright? Sometimes they have those kind of provisions. So it just depends on what your deal is, your agreement, assuming there's an agreement that drives this as to whether you should be registering it or if they're going to be registering it, and how they take care of your portion of your interest as far as your portion of the royalties or whatever. So it just depends on the type of deal you have with the music library.
Okay. Let's see, I had one in here and in the chat, and it had to do with jewelry. It says, I make duplicate jewelry. How do I protect my design / creation? Do I have to do each item, or can I do collection of items? So maybe you've already answered that one.
Maybe so. I mean, if it's the same piece, you only have to copyright it once, right? But if it's variations on that piece, then yeah, the collection makes sense. And every piece will have its own kind of original date of creation.
So jewelry falls under copyrights, correct?
Absolutely. Designs.
And those are our questions right now, but I want to talk to you about two things. One, how do you protect people from infringing? And what's a good theory on protecting?
Oh, okay. Well, when clients come to us and they have a infringement situation, then what we might decide is, depending on the size or of the company, what kind of company it is, and what how they litigate, we might send a letter out, that says, here's our patent, here's what you're doing, you're infringing, please cease and desist, or let's talk about a business arrangement, if you don't want to be so forceful about it. It seems like we have similar interests and we should have a discussion. So hopefully you could talk that party into a license, unless you want to try to keep them out of the market. If that's your objective, is to stop the infringement because you want that market to yourself, then that's a different story. And the only way to do that is probably to litigate. They may not just stop because you wrote a letter, but sometimes we'll just file the lawsuit and then give them notice and then go into negotiations, or maybe a little bit of litigation, discovery, stuff like that. And then usually these things settle, but sometimes these cases go all the way to trial. But the majority do settle at some point and it ends up being in a licensing agreement.
And then I'm going to launch the survey in a bit, but I have two more questions. So I want you guys to please fill out the survey. On AI and copyrights, right? But what's the deal?
Oh, AI. It's become very interesting, isn't it? We're finding that AI is finding its way into a lot of the law practice, as well as patent disclosures that we're getting and that we're filing patents for, patent applications for at the patent office. And I guess the thing about AI is it's not going to go away. I think it's starting to find its way into everything that's kind of IT related and, computer related. In fact, I feel like I've had this discussion with my law partner. It's almost like we have to say something about AI in most of these patent applications, or, we may not be doing justice to our clients because, it's in everything. But AI is also being used to assist attorneys with their work, which is kind of interesting, as it assists everybody else, to find answers to things and conduct research. You got to be careful with that stuff, but it's interesting what kind of output you can get from like ChatGPT and these other platforms. And it's kind of shocking, actually. Yeah. Well, I'm not sure I answered your question, but is it important? It is. And is it changing things? It is, in a big way.
And then, so I have clients that starting up businesses and then they're working on their trademark. They want a trademark, right? And so they said, oh, well, I had my logo done. And because maybe a business did their logo, it's important that they make sure that they obtain the copyright. Is that correct?
They want to get the trademark. Yes.
They want to get a trademark, but they had a logo, right? And somebody did the logo for them, right?
Yeah.
And so they paid that person to do their logo, whatever it is. Okay. But you want to make sure that you own that, right? And it's a logo, right? It's a drawing.
Well, yeah, it's true. You can file for copyright for that too, because it is
Yeah,
a
right.
design. In fact, it's interesting, but there's three types of intellectual property that kind of overlap. They can overlap. And that's copyright, trademark, and design patent. And I'll just give you an example. The Jeep grill, the distinct Jeep grill, that has design. They had a design patent on it. I don't know, it probably expired by now, but it had design patent protection. It has trademark protection because it is kind of distinct. It's a trade dress thing. And the design also is copyrightable as a design. So it's interesting how something like that can overlap all this intellectual property. So yes, you can register for the design in the Copyright Office, as well as file for trademark protection for the logo, for the design.
So that is like the person providing the logo, the artist, okay? That's the way they make their living, right?
Right.
Right. So originally, they own the copyright because they designed it, even though they got paid for it. Does that fall under work for hire or?
It would fall under work for hire, and if it's an employee, it's automatic. But if it's a contractor, it should be in the language of the agreement. There should be some sort of agreement that they have, that with that designer, that they are going to own the design. They're going to own the intellectual property, underlying intellectual property in the design, and there's agreements online for that. I mean, there's simple one-page agreements for that, but it is important to have that confirmation that it's the companies, or it's the party that's buying it from the designer.
Buying it.
Yeah,
Because I have both people. I have both people that are starting the business, being the artist, right? So I was trying to make sure that you determine who's going to own that copyright of your artwork, because it's work for hire. And then I have people purchasing that, and I tell them, make sure you own that copyright so you can do whatever you want to. And so that's,
I always feel it's cleaner to have a simple agreement than have, wait for a problem later. Doesn't always happen, but sometimes it does. Now this design is showing up somewhere else because you didn't get the transfer of the underlying design, the ownership of it.
this is great. I have another question. And it says, where can you find previous quilting ruler patents so as to prevent infringements? Under what category on Library of Congress website?
Okay, so quilting ruler patents aren't going to be at the Library of Congress. It's going to be at the USPTO. United States Patent and Trademark Office has a search tool where you can search for quilting ruler patents. Probably just put that in, those 3 terms, to see what comes back. You can also go to Google Patents and search. It's another database, which is pretty good, and so you go into Google and you do Google Patents, and it comes up with a separate database that holds all the patents, and you could put in the terms, or what you're searching for. And I think, I forget what that was, quilting quilting ruler, and see what comes up. And there might be quite a few, but if you have an idea that's different, or an improvement on something that's old, might be an improvement on something that's already expired. So you wouldn't even have to worry about permission, because it's past the time period.
And also on that, we have that PTRC, and it's down here at New Mexico State, and you can make an appointment with them, and they can help you with the searching, with the prior art searching. I am going to launch the poll, and we're going to still keep this open, but I need you people to please fill out the survey, the training survey. And can you all see it? Yes, no? Can you see the survey?
I see it.
Okay, great. Okay. And while people are filling that out, oh yeah, thank you, Francisca. Let's see if we have any more questions. You talked about a cooperative agreement. What was that?
Oh, is that the CRADA, Cooperative Research and Development Agreements?
Yes. Oh,
Yeah.
okay.
Over
That's
the universities? Yeah,
okay.
yeah. So what about them?
No, I didn't know what they were, but they're the.
Oh, yeah. So they're pretty nice tools. I mean, what it is, if you enter into a cooperative research and development agreement with, let's say, Sandia Lab, or one of the laboratories, right? It allows them to jointly do research and development with you, and they bring something to the table, and you bring something to the table. You might bring money and intellectual property, and then at the end of that CRADA, there'll be maybe maybe a prototype, or maybe something's proven out, right? That you need to proven out scientifically or engineering wise. And that information is important to get to the next step for the company. You know, maybe the next step is actual production, or maybe further testing and prototyping. But you know, it brings parties together with the lab to tap into that expertise. Now, the only risk there is there could be jointly created intellectual property. So you might end up with intellectual property that is owned by the lab and owned by you, or owned by the lab and licensed to you, you know, or, you know, so sometimes those rights have to be sorted out. So before you get into CRADA, just like the SBIRs, if you have intellectual property, it's great to maybe register it, or at least file a provisional patent application for it before executing that agreement. So that that initial background IP, the initial concept at least, belongs to you. It doesn't kind of become something that's encumbered by this creative process.
I wanted to give a shout out to New Mexico Tech. They are having an innovation and entrepreneur workshop tomorrow. It's a full day of presentations on intellectual property. People from New Mexico Tech will be doing some pitching. We'll have some CVs there. It's free and it's live, and it's going to be here at New Mexico Tech at 8 o'clock. If you need the registration, you can get a hold of me and I can give you the link. Actually, I should just find it and put it on the website or on the Zoom. Do you have any other comments regarding intellectual property? I know you got copyrights, but you wanted to do some patent talk, but we're.
Oh no, I'm fine with all of it. You know, like we do a fair amount of copyright, but maybe it's mostly on the litigation front or licensing, as in that jewelry case. But you know, on the patent side, that's probably about, I'd say that's about 80 to 90% of our practice is patents. So we do quite a bit of patent filings before the patent office, and then trademarks, I guess, would be the next one. So it's like patents, trademarks, and then copyrights. I encourage. Sometimes people call with designs, and I just tell them, look, the process to register your copyright isn't that hard. I mean, you can pay me by the hour, or just you know, it's not that difficult to do it online and submit it. It's the other stuff, the licensing, the litigation, you know, those agreements, those kind of things that we usually end up getting involved in with copyright.
Yeah, and and nowadays, I know, I have some other questions. Nowadays, people have e-commerce, right? And so then I have photographers, jewelry makers, like people, and the infringement is just rapid out there, you know? And
Yeah.
so, what do you recommend for our?
Well, you know, on online platforms, there is a way to notify, like if it's Amazon or some of these companies, that there's an infringement. You know, there's a process to notify them of that. If you have a registered copyright and or you have a patent and somebody's infringing your work or your invention or your product, and it typically is maybe maybe it's an entity outside of the country or something. Well, either way, you can notify these platforms, and they typically will get involved and, you know, investigate it, see if they need to like freeze the site or freeze that particular product or whatever until it's resolved. So there are processes for that. Because you bring up e-commerce, and a lot of the e-commerce sites, they run into this all the time, you know.
And so they know the servers, the people that provide the servers for their websites, they know how to handle that, right? So
Well, there's a process to at least deal with the platform. As far as the infringement goes, that's a separate process. They're not getting involved in that. They might assist you if you're having a problem and somebody's selling infringing articles. But in order to stop the infringement or to get compensated for the infringement, you'll have to start maybe an infringement lawsuit, or have an attorney contact that other party. to tell them to cease and desist their activity.
I put the link to our innovation and entrepreneur workshop tomorrow. I put it in the chat. So if anybody's interested in coming, we will be there. I will be putting on a booth. I'm not talking this year, but it's like their 7th or 8th annual innovation and entrepreneur workshops that they have here. So anybody that would like to attend, you're welcome to check out the link and see it's there. Okay, what else? Any other questions from our clients that are out there listening to this presentation? I hope you have learned something during this presentation. It's intellectual property is just so exciting. I'm even dealing with pictures and photos and the copyrights. So some of my artists, I tell them, you know, you sign your art. Does a copyright help your photos for some, so you're protecting, so nobody's infringing?
Well, yeah, I mean, you can register on everything, but if you wanted to just wait, you know, if you find that there's an infringement, you can register your copyright at that point and wait for it to actually become registered, and then pursue the infringer if they're still conducting that activity. Because, you know, you're claiming a creation date for your work. You have that common law copyright infringement, but you don't get the statutory damages until you're registered. And the prior infringement, statutory and damages won't apply to that, but infringement after you get the registration falls under statutory, you know, statutory damages part of it kicks in, as well as attorney's fees and things like that. So, you know, sometimes it's good to be proactive about the work and just go ahead and just copyright it. It's not a difficult process. It's not expensive, but it's never too late to do it, even after you've detected a copying by a third party.
And then also on a trademark, when you're doing prior art search, you know, I know that you can't have the IC, the international class, the same with like the same name. How close do those names have to be? I know, like, if it sounds the same, it is the same.
Let me give you an example. There's a lawsuit, and it's kind of it's a case that, you know, we studied, I think, in law school, but it's Lexis Research, you know, the research company, LEXIS.
Okay.
Sued Toyota for using Lexus for their automobile. And they lost because they weren't in the same classification of goods and services. So Lexus was still allowed to, and Toyota was still allowed to use Lexus for that brand, for that automobile. And the rationale there was that Toyota was never going to be selling illegal research and, you know, services, and Lexus is not going to be selling automobiles. So there really couldn't be a problem there, I guess, as far as trademark protection and infringement.
Mm-hmm. Yeah, and I think of the anybody who's had a counseling with me will know about Dove chocolate and Dove soap products. They're the same. They spell the same.
Oh, yeah.
And then, but
classes of goods and services.
Yep.
So the test is, what's the likelihood of one going into the other's business, you know? Now, the closer it is, of course, it's more difficult. So if you've got a bar maybe that sells food, and then you've got a restaurant, right? And they have the same kind of name, I guess. There's a likelihood that the restaurant will start, you're going into the bar business, or open up a bar in the restaurant, or that the bar will expand their offerings to include dining in, like a restaurant, instead of just bar food. You know what I mean? So those are close.
yeah, very close.
That would definitely be a situation where the registered trademark holder could keep the other party out, most likely, because it's too close now than the other examples we were using.
And on trademarks, the name, people want to always use their name. Is that acceptable?
Yeah, well, the trademark name, it depends. I mean, the best marks are arbitrary and fanciful. You know, they're things that like Meta, you know, it's kind of didn't say anything about what the business is doing, or Apple and the Apple logo. They're not selling apples or fruit, right? They're selling computers. So that's kind of arbitrary, right? And the fancifulness is the kind of the color of the apple pattern and stuff like that. Those are strong marks because of that. Now marks can, even if they're a little descriptive or whatever, over time can still get some secondary meaning in the marketplace. Like after 5 years of continuous use, there's an assumption there might be secondary meaning. So then maybe something that seems descriptive might still be able to get trademarked in that case, because the market is recognizing it as associated with that origin, that company that's selling those goods and services. But, you know, again, it's not as strong as those arbitrary and fanciful marks.
We have another question, and it says, can one register a series of paintings under one application? Example, one filing fee. In other words, if there are multiple paintings, do you have to file separately for a copyright, or
Well,
can you?
yeah. So you have the ability to file for a collection of works. So if they're associated with each other, there's the collection, you can file under one application for the collection. And I'm not sure the fee's just $45, but I don't think it's too much more for a collection.
Yeah, and you can do groups of photos also, right?
Right.
And you
It
can
could
do
be a
those.
collection.
They go by year and stuff like that. So that's good.
Yeah.
Well, I have 16 out of 16 that answered the survey. Thank you, guys. Thank you. Our time's coming to an end. We have a couple more minutes if we have any more questions or any more comments. Every year we got thank you. This was great. Thank you, Louise. Always good to refresh our understandings of copyright. You made me even smarter. And when you get the slides, we can go look at the demo for your David Bowie and Ice Vanilla.
Yeah, I'm sorry that didn't play. It played for me. I just don't understand why.
Yeah, you can hear
Couldn't
it,
hear
but we have to hit a setting on that, so that's okay. We can get the slides. So
Here's
what will happen is we are recording this. This webinar will go on to our YouTube channel, and then all the attendees will get the presentations and the link to the channel. So that's what we have.
There's
And
an interesting question about AI. I'm writing a book about my field of work and I use AI to do a great part of it. Do I have a problem copywriting it? That's interesting. But I think it's still, you know, something you can copyright because, you know, the ideas are coming from you. You're telling maybe AI what you're wanting it to write about, and it's coming back to you sort of like an employee or contractor and giving you that output. That's how I look at it. And at the end of the day, you're probably massaging some of that text, you're editing it, you're creating a final product from what you got from AI, and that final product is what you're probably going to register. So I think it's fair game. And you know, there's a lot of debate about whether AI can be an inventor or be a creator. You know, it's pretty sharp, and sometimes it can. You can throw out a problem to it and it could come back with something that's just terrific. So I think the law has to catch up to technology all the time. It's a little behind every time, but for right now anyways, our position is it's still copyrightable if it's a work and you can still own it. And if it's an invention, well, as long as there's some modification, I believe it's something that you could be the inventor on, even though you had the assistance of AI. Until there's a case law that comes down differently. That's how we feel.
so on the copyright, would that be just like a deviation? Is that what they call it?
Derivative work?
A derivative work?
No. Here's the one thing that there is concern about with AI is where's it getting its information from? You know, so could there be portions of what it's giving you that is lifted from some other author's book or something? So anything you get from AI should be, somewhat modified, significantly modified in some cases. I mean, you get something and then kind of like change it around a bit. And I think that's what's going on. I think that's what's going on with students in college, right? Is they get some output from AI, and if they just submit that, it's not a good thing. They got to work with the research they were provided and modify it.
So Lynn says that I'm editing the AI and modifying drastically.
And we should be good to go.
Okay.
Yeah.
And then Julie thinks she answered her own question regarding my earlier comment on how many differences from an earlier patent.
Oh,
So
okay.
I'm
Yeah.
glad you were able to think that through, Julie.
Well,
That's
just to continue it, just to add to that, really most patents that are applications that are filed are disclosing an improvement on something else, an improvement on what exists in the prior art. It's hardly ever that it's a pioneering invention, that it's so brand new that there's no prior art. So everything's an improvement. It just has to be novel, not obvious, right?
and that will come out in the claims.
And during the examination, for sure. So there's some element in the claims that is original, not original, but novel and not obvious over the prior art. And sometimes there's a little fight with the patent office. They'll try to reject it, and we have to fight back and forth a little bit about its patentability, maybe modify the claims. But I feel like most inventions are improvements on what already exists.
Okay, Orania, are you giving us that message? Where it says tickets are sold out? Says tickets are sold out, yes. What tickets? Where does it say that? We had a sold out show. Oh, for registration. Oh, for registration for this webinar? Oh, for tomorrow. Oh, for tomorrow. Oh, okay. Come by anyway. If you want to come by. It says tickets are sold out. She probably closed the webinar. No, it's for the conference tomorrow. Come by and look for me, Orania, and I'll get you in. Okay, I'll be there. And you have my phone number, so call me. Okay, so she was saying that the tickets were sold out for the I&E tomorrow, so. And I have one more new message. Okay, she has my number, okay. Well, thank you all for attending. Thank you, Mr. Ortiz, this was so nice. I'm sure I will bring you back in, because we do trainings all the time,
Oh,
so.
thank you. Yeah, we're happy to do it.
Okay.
I wish everybody luck in whatever their endeavors are, whatever they're creating or inventing or pursuing. So, yeah, thank you very much, Stephanie.
Okay, well, thank you. Okay, everybody, you're free to log off. Thank you.